This is Debt Free in 30, where every week we take 30 minutes and talk to industry experts about debt, money, and personal finance. Here's your host, Doug Hoyes.
We've got a great show for you today with a guest who has a lot to say about the world of debt and finance, but he isn't an accountant or a bankruptcy trustee or a financial advisor or a journalist. So I think it's going to be a great show with some unique perspectives. So let's get started. Who are you and what do you do?
So I am Vance Lockton. I am a senior analyst for stakeholder relations at the Office of the Privacy Commissioner of Canada.
Thanks for being here, Vance. What is the Office of the Privacy Commissioner of Canada? What do you guys do?
So the Privacy Commissioner of Canada, his name is Daniel Therrien at the moment. He's an officer of Parliament, so that means he reports directly to the House of Commons and the Senate. He's independent of the government of the day, so the election didn't change our boss. We oversee compliance with two acts. It's the Privacy Act, which covers the personal information handling practices of federal government departments and agencies, and PIPEDA, the Personal Information Protection and Electronic Documents Act, which is the federal private sector privacy law, and that's the one that I'll be speaking to during this discussion.
And what is the difference between the Privacy Commissioner of Canada and the Privacy Commissioner of Ontario, or is there such a thing?
There is such a thing. So there is an Information and Privacy Commissioner of Ontario. It's essentially a jurisdictional difference. So we oversee commercial activity in the province of Ontario. In the Information and Privacy Commissioner of Ontario oversees collection of information by health institutions, universities, schools, as well as municipal and provincial governments.
Gotcha. So there is a bit of a difference there. So, well, I mean, this is a show about debt, so perhaps we can start by talking about how your work intersects with the world of debt, and I'm thinking in particular about collection agents, because that's a topic we've discussed many times on this show before. And it's, I'm guessing, an area that people tend to get upset about and have complaints about. And so I guess let me start by asking you, from a privacy point of view, are there any limits, or what are the limits on what a debt collector is able to do?
So, in general, debt collectors will be subject to the provisions of PIPEDA, unless they operate in certain other provinces that have substantially similar legislation, such as Quebec, Alberta, and British Columbia at the moment. But that act is a principles-based law that kind of sets out the ground rules for how private sector organizations can collect, use, or disclose personal information. So, for example, any organization subject to law, including debt collectors, would generally be required to obtain consent for the collection, use, or disclosure of personal information. And they're required to protect personal information using appropriate safeguards. There's a list of 10 of these principles. And there's also an overarching clause that personal information may only be collected, used, and disclosed for purposes that, quote, a reasonable person would consider would consider appropriate under the circumstances. So that's kind of the general principles-based things that debt collectors are controlled by federally. Now, provincially, there are other laws that they'd be subject to. I mean, Ontario has their Collection and Debt Settlement Services Act that sets out certain limits. But again, because our office doesn't oversee that, I'm not really in a position to speak to the details of it. But there's some good resources online for both debt collectors and debtors that set out the principles of that, and I'll provide a link for that for your show notes.
Yeah, that'd be great. Our show notes will be available at hoyes.com, HOYES.com. So anything we talk about today, we can reference there, and anybody listening, more than happy to have you go there and click on the links and get more information. So you used the phrase, I'm paraphrasing a bit here, but you said reasonable and appropriate in the circumstances. So if I'm a debt collector, for example, I'm supposed to have consent and I'm supposed to protect whatever private information I get, but whatever I do, it has to be reasonable and appropriate in the circumstances. So can you talk practically about what does that actually mean? So what would be reasonable and appropriate, or what would definitely not be reasonable and appropriate when it comes to private information of people?
So I'll start with one interesting piece. So while there's the general requirement for consent for disclosure of information, there is actually an exception with our law, specifically speaking to debt collection, that says that information can be disclosed without consent for the purposes of collecting a debt owed by the individual to the organization. So again, that's what kind of allows banks to disclose information to debt collectors and things along those lines. Again, that exception doesn't give organizations carte blanche to disclose any information they wish or to any parties they wish. And just kind of by way of example, we've got one of the things that our office does is publish what we call case summaries. So just kind of interesting points of law. We put them on our site. It's priv.gc.ca, and I'll kind of give some links to specific cases here. But well, an example of kind of almost the overstepping that we've seen is case summary is 2004-282, and we kind of saw that a bank, this happened to be a bank, that was calling complainant's company just to ask in order to start the process of garnishing this person's wages. But during those calls, the bank's collectors kind of disclosed, again, much more information than was necessary for that purpose. So we were given evidence of a voicemail recording that was stated in part, I don't know what type of company you're running, but given the complainant's history of not paying bills, I can't really say I'm surprised by your lack of professionalism. So we were hearing things like that. So our assistant commissioner at the time recognized in her findings that a debt collector has to be able to disclose some information to an employer when seeking to for example, garnish a debtor's wages. But here the bank had gone too far. So they had revealed, the debtor's payment history, the amount of money owed, the fact that the debtor's credit card was suspended from future use. And we kind of said that none of those pieces were necessary to match the purpose of starting to garnish this person's wages. So that's kind of where we will be looking is what is the purpose for making a call or making a particular disclosure, and is that reasonable, first of all? And then second of all, is the information that's being revealed beyond that which is necessary to serve that purpose?
So if I'm a debt collector and somebody owes money, I want to garnish someone's wages, obviously I've got to go to court and get a judgment and everything. I can't just do it. But let's assume that I've done that. I've got a judgment. I just don't know where the employer is. I think I found the employer, so I can phone up the employer and I can say, does so-and-so work here?
Right.
That would be reasonable and appropriate in the circumstances to ask that question.
Right. And again, we have to say, just given our role as an oversight body, we can't give, in essence, advanced rulings on a particular matter. we kind of have to say it, as I keep saying, the context matters. So it's hard to speak in generalities, but yeah, something like that. Like we've seen cases where, again, on our site we can point to cases where we kind of say, a bank has a customer whose loan's gone into default. They can't find him, so they call his ex-wife, and they call his ex-wife's lawyer, and they call his daughter. Just again, all in an attempt to find this or to be able to locate this individual. And again, they didn't reveal anything beyond the existence of a debt, and obviously the fact that it relates to this person. And we kind of found that to be reasonable. We kind of said, no, that's a reasonable amount of information to have disclosed for the purpose of trying to find this person.
So trying to find a person is one thing, but where in the case you cited they went over the line was when they started disclosing more information than necessary, such as, the guy hasn't made his credit card payments for years and his credit card's been suspended, and that's not necessary to track the person down, and therefore that's not reasonable in the circumstances.
Right.
So what is the penalty then? So let's say I'm a consumer who has been egreged by what you've just talked about. I do owe money to a bank and I haven't paid, but that particular bank has called my employer and released a whole lot of information that they shouldn't have.
Right.
What steps should I as a consumer then take?
So if you visit our website, there's right on the front page of our website, there's a link that says "Need Our Help," and on that site, there's contact for both our information center. If you just want to ask a question to one of our information staff. Excuse me. And there's also a link to file a complaint under PIPEDA. So there's a simple form to fill out that kind of just you would describe the issue you're having, describe why you feel that there was a problem with a particular disclosure that was made, and we would then investigate the matter.
And really, yours is, I would characterize it then as a complaint-driven organization?
Yes, we are a complaint-driven organization. We do have the ability to have commissioner-initiated complaints as well. So if there is an issue that comes to our attention that we haven't directly received a complaint about, we do have the ability to have our commissioner initiate a complaint, but generally, 95% or more of our complaints are ones that we receive from individuals.
Which kind of makes sense, because it's impossible for you to be out there watching every single thing that goes on in Canada. You're not Big Brother. People have to bring these things to your attention in order for you then to take action. So I do what you say. I go to the website, priv.gc.ca. I click on either English or French, and I click on the Need Our Help button. I fill out the complaint form. Your organization then would investigate it, and let's take this case that you quoted. The bank obviously was in the wrong. Well, that's what you decided. Your organization decided. So what happened to the bank then? What was the upshot of it?
So what happens next at that point? Once we've issued our findings, we have the ability to go through a few steps. So what we're trying to do through our findings and through the complaint process in general is come to a resolution. So we are working to ensure that the organization does have the appropriate practices in place. They do have the right consideration of privacy and a right understanding of privacy. So in the case that we cited, there wasn't a lot of follow-up that happened, partially because the debt collectors in question for the bank no longer worked for the bank by the time the complaint was finished. However, there is the option with any report actually to then take an action through the federal court, whether that's attempting to recover damages if damages can be established, or enforce changes, enforce recommendations that we've made. So the follow-up for us, the follow-up that we have available and any complainant has available is immediately federal court. We've also seen a number of instances where our reports are used by individuals, again, who, if it's established they're aggrieved that they've taken that as a piece of evidence in a small claims court action, or in an attempt to reach a settlement independently with the organization that's aggrieved them. Again, those aren't formal mechanisms. Those are just kind of things that we've seen happen in the past.
And I would assume that a lot of the success you have is really in the category of moral suasion. That by highlighting this is an activity that isn't appropriate, I suspect when you go to a big Canadian bank and say, hey, your collectors were doing that, their response is probably to say, you know what, that isn't right, you're right, we're going to stop doing it.
Right, and that is kind of our strongest power. And one of the things that we are able to do is we almost have the potential for almost like what I would call a marketplace impact of we have the ability following a complaint, the commissioner is able to publicly report on the personal information handling practices of a public or private sector organization. So should we determine that it's in the public interest for individuals to understand that this is how this organization is treating personal information, we have the ability to again publish the file and name the organization.
And that's what really brings them more into line, I guess, rather than having some federal court case on it. If I'm a big bank, I don't really want my name associated with something negative, so I'm probably going to come into line, and it's kind of marketplace regulation, I guess, is what it really is. You don't have to use the courts as much as just putting it out there. So that's probably a very good model, I would think. I want to ask you about another court case, or maybe not a case, one of your case files, good old 2015-002, which is referenced on your website. And in this particular case, there was a company that operated a website, and if I understand correctly, they republished Canadian court decisions, tribunal decisions, that sort of thing, which contained people's personal information. And your organization had some issues with what they were doing. Are you familiar with that case, and do you have any comments on it?
I am. I funny enough, I happen to be the investigator on that.
There you go. So you're very familiar with it then.
Yeah. So yeah, with that case, the organization was collecting court documents from what we'll call more legitimate legal sources and republishing them online. And the primary difference between what they were doing and what some of these other legal sources were doing is that they were allowing those documents to be indexed by search engines. So it kind of changed the accessibility, as opposed to somebody having like a legal researcher kind of going to one of these sites and trying to find case history on a particular issue. Now we were seeing issues where individuals could be just doing a quick search for their own name, or search for the name of a friend or what have you, and all of a sudden within the top few results of their site, we were seeing their bankruptcy file listed, or a custody case, or a divorce hearing, or a lot of very kind of sensitive interactions with the court system were being published. And to top that off, we had this organization that was saying, well, if you don't like that, you can pay us a fee, and we'll take that page down off our website so that it no longer appears in search results.
Blackmail.
Yeah. We try not to use the blackmail extortion term, but it's kind of there's the implication that we try to make that's essentially what it was. Well,
fortunately, I got my own radio show here, so I can say whatever I want, you see, and
there you go.
I'm not limited by any specific rules. So, yeah. And the point is, I guess, this was publicly available information, so if I knew where to look for it, I could find it. And your example of a divorce case. So we're arguing over splitting of assets, child custody, whatever. So a lot of facts have to come out as a result of that. Obviously, those are court records. The court has them. But that's totally different than then putting them into a place on the internet that Google can index them.
Right. And we recognize there's a legitimate reason for these documents to be published in the first place. I mean, there is a strong rationale for having open courts that publish their decisions, so that there is that level of transparency and oversight for courts. But the Canadian Judicial Council itself actually said in its rules for making those publications, that they said the intent isn't to associate that with search results for an individual's name. We're trying to create court transparency. We're not trying to saddle an individual with all the details of his divorce or bankruptcy for time immemorial.
Yeah, and so what you're saying is there's a big difference between information being published online and information being published associated with my name online.
Right. So there is a differentiation within our legislation of what's called publicly available information. The term probably doesn't mean what most people think it means. So there are again exceptions to the collection, use, and disclosure requirement for consent when we're talking about, quote, publicly available information. But that term, that publicly available information, only refers to it's very, very strictly defined to generally things that governments have published, so court records or a phone book records, things like that. So first of all, there's a limited definition of the term, and then second of all, the exceptions of how that information can be used only apply when that information is used for what's called a purpose consistent with that for which it was initially published.
Gotcha. Well, that's very interesting. I'm going to take a quick break here, and I'd like to come back and ask you a bit more about how social media fits into this. So we'll take a quick break, and I will be right back with Vance Lockton. You're listening to Debt Free in 30.
You're listening to Debt Free in 30. Here's your host, Doug Hoyes.
Welcome back. It's time for the 30-second recap of what we discussed today. On today's show, Vance Lockton from the Office of the Privacy Commissioner of Canada gave us some examples of the meaning of the phrase reasonable and appropriate in the circumstances as it relates to the privacy of personal information in Canada. That's the 30-second recap of what we discussed today. I was glad to have Mr. Lockton on the show today because he shared an interesting perspective on how information you may think is private may be used by various organizations, including bill collectors. I completely agree with his advice. Whenever anyone asks you for personal information, ask how it will be used and don't ever give out more information than is necessary. A social insurance number, for example, is an identifier number for Canada Revenue Agency, so there's never a reason to give your SIN out over the phone to anyone. It's private information and you should keep it private to protect your identity. That's our show for today. Full show notes are available on our website, including links to everything we discussed today, so please go to our website at hoyes.com, that's HOYES.com, for more information. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.
Thanks for listening. That was Debt Free in 30.